Nearly 1 million tenants are behind on their rent according to figures from the Rowntree Foundation, but as most COVID-related eviction protections for residential property renters have come to an end, what are your options as landlords to recover the money that you're owed? I'm Daniel Barnett, a barrister based in central London and the presenter of the Legal Hour on LBC Radio. In this video, I'm going to explain the steps to take before going to court, the procedures to follow when evicting tenants, and the circumstances where you have to wait to recover arrears. Before we delve into the details, please do subscribe to this channel and click on the notification bell to receive alerts for my latest explainer videos. If you're a tenant, you might, for instance, be interested in this accompanying video. I'm being taken to court for rent arrears. Under the Tenant Fees Act 2019, you can charge your tenant a late fee if there's a provision for it in your tenancy agreement and if rent is overdue by more than 14 days. The amount you charge as a late fee is capped at 3% above the Bank of England's base rate, so it's essentially interest at a slightly higher rate than base rate, which is incredibly low anyway. Agreeing a repayment plan with tenants can help to maintain relationships and to avoid unnecessary and costly court action and save you from having to find new tenants. It doesn't, of course, stop you taking legal action if they then fail to keep up with the payments, but you're unlikely to be able to evict them if they stick to the repayment plan. You don't have to agree to a repayment plan, you can move straight to possession, but as I say, that can be costly and you may have a void period with no tenants. If your tenant receives universal credit or housing benefit, you can request managed payments as an alternative to eviction. The relevant form is linked to in the show notes below. If granted, you'll receive the rent directly before your tenant is paid the remainder of their benefit. If you aren't able to agree a repayment plan, or if your tenant fails to keep to it, you can move to evict them under grounds detailed in Schedule 2 of the Housing Act 1988. This is for assured tenancies, which is what the overwhelming majority of tenancies in the private sector are. Keep in mind that as of the 1st of October 2021, the only COVID protection still in place for renters is 14 days notice from bailiffs, and a temporary halt on repossession if they're currently suffering from the virus. You must send your tenants a 2-week notice of repossession through a completed Form 3, a notice of intention to begin proceedings for possession of a property in England let on an assured tenancy or an assured agricultural occupancy, alongside a copy of the corresponding government guidance notes, which is linked below. If your tenant owes more than 2 months' rent, the court must grant possession, which means order eviction. If your tenant owes less than 2 months' rent, the court has a discretion whether to order possession or not. Now, there's an exception if you're notified that your tenant's been given what's called a breathing space under the debt respite scheme. This usually lasts for 60 days or longer if your tenant's suffering from a mental health crisis. And where this applies, you must implement certain protections, including stopping all action to recover arrears, curtailing any fees accrued during the breathing space period, including penalties and interest on arrears, and restraining from contacting your tenant regarding repayment. Now let's turn to possession orders. Accelerated possession orders are only appropriate for cases where tenants fail to leave your property by the end of their contract. To evict them in these circumstances, you can use a Section 21 notice, for which you usually have to give your tenants 2 months' warning. To claim back rent arrears, you have to make a separate claim through the courts. Accelerated possession orders are usually approved after 14 days after your application has been made. Your application costs £355 and your tenants are then required to move out. In exceptional cases, they may be allowed to stay for up to 6 weeks. That's an accelerated possession order. A standard possession order also costs £355 up front. You might get an order issued, or the judge could decide to conduct a full hearing. There can be various types of orders made. An order for possession gives your tenants a date by which they have to leave the property, 14 or 28 days post-hearing. Otherwise, you can get a warrant for possession. A suspended order for possession places conditions upon your tenant, such as paying you money. The court can evict them if these payments aren't made. Money orders dictate how much your tenants must pay you. If they default, the court can take payments from their wages or from their bank accounts, or send in bailiffs to recover items that they own. Subsequent rent arrears can be dealt with through a possession order. Any of these orders might also come with a money judgment, mandating that your tenant pays your legal fees and pays the court costs, as well as their rent arrears. Where you're required to attend a hearing, the judge can still make one of these orders. Alternatively, the judge might dismiss the case if your tenants have already paid their debts, or if you or your representative fail to turn up to court, or if you haven't followed the correct procedure. Now, the judge also has the option to adjourn, that means postpone the hearing, if the judge doesn't think the case can be decided that day. If the judge makes a mistake, you have to ask for permission to appeal at the end of the hearing. The appeals process involves further court fees and should be undertaken as soon as possible. You can apply for a warrant for possession online or through a form N235, linked in the show notes, anytime within 6 years of an order being made. It costs £130. It gives bailiffs the right to evict your tenants if they don't leave when they're supposed to, or in the case of suspended possession orders, if they renege on the stipulated conditions. If a warrant is approved, your tenant will receive an eviction notice telling them when they have to move out. You'll get a warrant number and you'll get a form that you must fill in and send back to the court. To evict your tenants faster, you can pay £71 to apply to change the warrant at county court level to a writ of possession in the High Court. Now, your tenants have the right to ask for a new hearing to suspend the warrant for possession or to change payments if their situation has changed. If you don't follow the correct eviction procedures, such as giving your tenants a proper notice period or causing them to feel unsafe in your property, you may have to pay them damages, and you can also be prosecuted under the criminal law. You must not attempt to force your tenants to leave through any action other than the court process. For example, you mustn't cut off their electricity or any other service, you mustn't threaten, intimidate or use violence against them, and you mustn't engage other people to create problems for them. You mustn't refuse to carry out repairs, or provide fewer keys than there are tenants, or change the locks. If you're convicted of harassment or of unlawful eviction, you can be fined or even sent to prison for up to 2 years. I hope you found this video useful. If you did, you might also be interested in my answer to an LBC listener's tenant deposit dispute. I'm Daniel Barnett. Thank you so much for watching. Please do subscribe if you don't already do so. You can subscribe below. The notification bell is there as well. Bye bye.